Good morning to everybody. I think we are ready to start this second hearing of our arbitration. First of all, a round of introductions. You know by now probably quite well. I don't know whether too well. Those on this side of the table, my colleagues Alain Pellet and Francis Tirriman, together with Annalisa Frankenstein and myself, Manuel Conte. We know the list of participants, but if you, Mr. Melsheimer, wants to go around your team, you're welcome to do so.
Good morning, everybody. To my left, we start with Andy Derman. You all know me, Andrew Melsheimer. We have Javen Porter. We have Cole Browndorf. Then we have Austin Finley. We have Jim Finley. We have, who you've all met before. We have Susan Barron. Then we are introducing to you all Mr. Alan Claiborne. And just to let you know, there will be I put a star by his name because we'll probably be discussing his ability to sit through the openings in a few minutes. On to Mr. Claiborne's right, we have Luis Kernian. You all have met Luis. We have his daughter, Helena Abramson. Then we have Dr. Rob Manis and his colleague, Brian Seeger.
Y ahora doy la palabra al señor Bonfiglio.
And now I give the floor to Mr. Bonfiglio to introduce his team. Thank you very much, Mr. President. For the record, my name is Alan Bonfiglio, and I have with me Rafael Rodríguez Maldonado, Rafael Arteaga Farfán, Oscar Rosado, Santiago Yaraguán, and virtually on Zoom, Sebastián Verduzco, all of them members of the Secretariat of Economy of Mexico, and also Stefan Becker with us, Gary Shaw and Carolina Plaza from Pillsbury. And we also have members of the FTI consulting group led by Jose Alberto and Veronica Irastorza, who are experts on quantum for Mexico. And let me start by saying that it is an honor again to appear before this tribunal. We are very pleased.
Besides those present here, you may know that there are 3 U.S. Department officials watching this session live, which are Lisa Grosh, John Daly, and Mary Muino, and we welcome them their virtual presence. Together with us are also our 3 interpreters, Monique Fernandez, Silvia Colla, and Charles Robert. And as co-reporters, we have Don Larson and Dante Rinaldi, and Thomas is helping us with technicalities. So before we enter into the full session, I don't think, are there any housekeeping matters that you want us to discuss at this stage?
Sí los hay, señor presidente.
Yes, Mr. President.
Which is very important. During this presentation and during this second hearing, Mr. President, I will address to the tribunal in English y en español. Haremos nuestro mejor esfuerzo.
We'll do our very best to have simultaneous interpretation so that it is sufficiently clear for the benefit of the tribunal and also for all of the representatives of claimants and also the people that are with them today. For us, it is very important to have a clear and accurate transcript in both languages, exercising the sovereign right that Mexico has to defend itself in its own language. That is the first comment. Secondly, as Mr. Melsheimer just said it, in this hearing room, we have in attendance the 3 witnesses of claimant. We have no problems with Mr. Finley to be here. We do not have any problems with having Mr. Kernian here with us. But we do have a concern with the presence of Mr. Claiborne because we would be going beyond paragraph 1810 of procedural resolution number 1. So with the utmost respect for all of those in attendance here and with the authorization of the tribunal, would like to ask Mr. Claiborne to be sequestered and also to come back whenever it is time for him to present his evidence.
Melsheimer has the floor to respond in case he wants to.
Yeah, we tried to raise this amicably with Mr. Bonfilio, but that failed. In conversing with Mr. Claiborne yesterday, he's really the best person to represent the interests that are involved here for Drake Mesa, the Mexican entity. And, you know, there are claims being brought on that entity's behalf, and it would stand to reason that that entity should be allowed to have a party representative. You know, I understand the purpose of sequestration. I get the rule. I'm not trying to dodge the rule. But all he would do is sit in an opening. I'm not sure there's anything in the opening that is going to be surprising or change his testimony. You all have it. He's not going to change anything. But I have no problem with him sitting in the timeout room while other people testify. I get the rule.
Señor Presidente, no es solo...
Mr. President, this goes beyond waiting just for others to present their evidence. This is to wait for the opening remarks of both parties, to wait for the replies of both parties, and finally wait for the right time for him to present his evidence and then to remain with us in person or over Zoom. But we do not think that claimant should... We think that two representatives on behalf of claimant is sufficient, and in this case the claimant is Great Finley, the claimant, and Drake Mesa, also the Mexican company. So we do not understand what Mr. Claiborne has to do with these two companies, and this would be up for discussion.
Rules applicable to this case to refresh our minds as to the rules exactly.
Mr. President, according to Procedural Order Number 1, witnesses are to be sequestered until they declare, and then they can be in the hearing room. Party representatives have been excluded from this rule.
Okay. So, I now turn to my colleagues. Shall we briefly consider this point? Yeah, just 30 seconds. Well, the tribunal has concluded that to the extent that you, Mr. Claiborne, are not a representative, technically speaking, of any of the claimants, you cannot attend this session. Could you confirm, Mr. Claiborne, as written in your statement, that you just represent MESA Southern Well Servicing, but not any of the claimants in this case?
Here. I definitely represented Drake Mesa.
I'm sorry, microphone, Mr.
And Drake Mesa.
Yes, I apologize. You are presented because we have been discussing in this about the meaning of Drake Mesa.
Yes.
There are at least two Drake Mesas.
Understand.
The Mexican one and the American one. And you come here on behalf of the American one.
Incorrect. Drake Mesa SDRL. I was in Mexico quite a bit and handled the operations for Drake Mesa SDRL. And Drake
Yes,
Mesa
no. I know that you have knowledge
Correct.
about Drake Mesa Mexico, but now, as of now, here you are not a representative of Drake Mesa Mexico, but of Drake Mesa the U.S.
I would think I'd be a representative of Drake Mesa SDRL. Correct.
Okay. Then, in that case, I think Mexico's position stands, and you should leave until tomorrow you testify.
Okay, no problem. So go ahead and leave completely.
And you cannot follow our discussions even remotely. You need to use that horrible word, sequestered, which at least in Spanish, secuestrado, seems horrible. In Spanish, secuestrado is equivalent to kidnapped, which I think is a very nice word. Then, once we have settled this point, any other question from Mexico, from claimants?
Let's go.
Gracias, señor presidente.
We thank you, Mr. President. On behalf of Mexico, nothing else. Thank you.
As I told you, the U.S. representatives from the U.S. Department are not making, the amici from the U.S. Department are not making any presentation or brief, but they're just watching us. You also notice that we accepted the idea of the expert for the claimants to be examined tomorrow, not the day after. And on that basis, I think, unless you have any other question, I give the floor to Mr. Melsheimer for his presentation, which should last at the very least 1.5 hours, but as much as he wants within his 3-hour limit.
I appreciate your comment about 1.5 hours, but I'll tell you, we're probably looking on the far end rather than the short end. So, in looking back on this, it's good to see everybody again. We've been in this case now for 5 years. Hard to believe. It was right before COVID hit. I can tell you Jim Finley and Luis Kernian have been through this ordeal for much, much longer. Probably the past decade. No one should have to go through what they've gone through. Now, I told you the last time I was here about the first time I met Jim and Luis. We had a meeting, you know the story. They told me about how they had brought all this equipment down to Mexico. And when I say equipment, it seems to be the recent focus has been 10 rigs, whether they're drilling rigs or workover rigs. As a technical, there's no difference. But it's more than just rigs. look at the pictures that we shared with you. To do the work under these contracts, all three of them, you have to basically set up camp from your yard, the land that they purchased, move the equipment, whether it's a workover rig, whether it's a drilling rig, on trucks, have people on site inhabiting. You have to provide trailers for them to live in, office areas for them to work in. And so I think we kind of get lost when we talk about rigs. I even learned before this hearing, my clients had to actually purchase an ambulance. It got down to that level of detail of what Pemex required of them. So it's a little bit more, I don't want you to focus on drilling rigs or workover rigs. It's a lot. Equipment is the proper word. That's why we have Mr. Claiborne here. He's going to the extent you have any questions about this equipment, he knows all about it. He can explain it. He can explain all the invoicing, everything. So, like I told you, you know what happened. Ultimately, my clients were encouraged to go into a bid round. We're going to talk about the bid round, and I regret for having to go through all of this. Sincerely, I say this. I do not want to have to go through the 821 contract in the detail we're going to have to go through. But when you receive a counter memorial like the one we received in this phase, and the level of absurdity of the argument that's being made, we're going to have to walk through it. So they were encouraged to go through this bid round, decided to make the bid. They did. Pemex, for whatever reason, decided not to ask for work. You all memorialized it in your decision. We don't have to really go back and revisit those facts. Decided they wanted to issue the bogus work order, which you found later the administrative rescission based on it. And then the court upholding the administrative rescission was a cardinal foul. I thought the same thing. When I met them and they gave me that fact pattern, having what Pemex had done, having what the administrative court had done, I thought it was clear on its face. But for me, the most unfortunate part of this process, and again, I say this with sincerity, I couldn't have imagined when I talked to Jim and Luis that night, it was at night, right before COVID, I couldn't have imagined what would continue after we started this arbitration. One would think it would stop. Unfortunately, the torment has continued. We brought it to your attention shortly after you were constituted, the efforts to do the unilateral finiquito and the call upon the Durama bond. You took issue with those actions, and you said you would address it later on. Now's the time to address what they did. You found those were breaches. I would have thought when you issued your decision, it would have been respected. You told the government of Mexico what they did, 5 breaches, independent breaches, especially with the unilateral finiquito and the Durama bond. You told them that was not good under the NAFTA. Yet they continue to this day. We still have a finiquito. I don't know the process of how you undo a finiquito. I don't know if you tear it up, if you do an administrative act. That has not happened. And Pemex is still calling upon the $41.8 million bond. For me, it's inexcusable. And it's also disrespectful to you, quite frankly. That's just Pemex. Mexico's conduct in this arbitration has fared no better. We just went through 2 weeks ago, and I told my young colleagues here who are new to the scene in the legal profession, it's rare they're going to catch somebody doing what Mexico did. It's not often you find somebody not telling the truth about their disclosure obligations. You saw through it, and you issue procedural order 15, and we'll go through some things all about those documents, and I thank you for that. I couldn't have imagined. What stuck with me, though, when you issued your procedural order 15, and you had to remind Mexico that its disclosure obligations was more than just the cover memo. They needed to include the attachment. They were still arguing about whether they needed to disclose attachments when that had been decided years ago. Since our first hearing, I have carried around with me, I don't know, maybe it's an obsession of mine, Exhibit C-103, to remind you. Exhibit C-103 is Mr. Rodrigo Lustenau. You met him last time we were here. That was his May 8th memo in 2017. That was the memo that Mr. Lustenau wrote to the commercial department, telling the commercial department, hurry up with your administrative rescission. I need to use that. I need to impute some misconduct, impute some non-compliance on the contractors for use in the civil lawsuit. I've read exhaustively now about this civil lawsuit, and we will talk about it. I don't run from it. I go back to your recent order. You told, once again, what, 2 weeks ago? Mexico, you need to disclose our order was to disclose all annexes to documents. Where is the attachment to Mr. Lustenau's May 8th memo? They have it. This did not go lost in the file. Why is that attachment important? That attachment was apparently a meeting on May 3rd, 5 days before. I wasn't at the meeting. I can only tell you what I can infer from Mr. Lustenau's May 8th memo and the sense of urgency he was giving the commercial department to hurry up with the administrative rescission. I suspect the meeting on May 3rd talked about the administrative rescission as well. It's a safe leap to make and conclusion to make. I encourage you to go back and read this memo, because I've sat with this and I've struggled with it. I struggled with it the last time we were here, a year ago, 2 years ago now. And I'm still wondering, in light of your recent order, where is the attachment? I would have thought when I got Procedural Order 15, Mexico would have coughed up what it hadn't disclosed already. Now, there's another memo, too, that I go back to the first part, not to relitigate facts, because you've already made your decision. But this is more about Mexico's conduct here. And it bothers me. When I tell you it bothers me, it really bothers me. You noted one of your breaches was a meeting that Pemex officials had in a town called Villahermosa in May 2019. May 2018. I have this memo too, that explains to you what it is. That's Exhibit C-128. The meeting on May 16, 2018 must have been important. That's the meeting that's mentioned in Exhibit C-128. Look at who attended. Pemex's legal department, both its civil division and its administrative decision. So there was apparently some coordination between the administrative lawsuit and the civil lawsuit. Its insurance and bond division, claim against the Duramavan. Its division for contracts of services for exploration and production, the people who run the contract. The subdivision of Pemex's legal department for the Southeast, the local lawyers within Pemex. Two more groups, something called the Multidisciplinary Group for the Attention and Betterment of SSE. I think that's Health, Safety, and Environment. And then finally, the Division of Well Intervention Services. When you have this many people to have a meeting about a contract, something important was going on. I'm going to ask again, in light of Procedural Order 15, where is the attachment to this memo. I should have gotten it when you issued Procedural Order 15. You clarified in plain terms. Disclosures include attachments. Quit playing games. Ultimately, you agreed with our view that the claim against the Durama bond, which apparently was decided at this meeting, was yet another breach of Mexico's obligation of the NAFTA. I know there's more documents out there. I think we all know there's more documents out there. But I can tell you from the documents that we were given, and I use the word given carefully because I think there was a deliberate effort to not give us documents. I really do. You can't explain this behavior otherwise. For me, it's clear from just the few limited documents I have here, Pemex was not pushing to administratively rescind the 821 contract. Pemex was not pushing to make a claim against the $41.8 million Durama bond. If there was only $2.75 million at risk, which is what Mexico and its experts claim was in play at that point. There's no logic to that. Companies don't have these kinds of meetings and don't take these kinds of actions for that type of amount. They would have just cut the check and moved on. Now, I will tell you, and this is why I give comfort, it's hard for me to criticize the opposing party or the opposing counsel when it comes to disclosure obligations. I don't like doing it. I take my responsibility as a professional very seriously. But we know there are documents because we just got one a week ago. We had to have a hearing with you all. I showed you, I walked through what we went through, and then mysteriously this unredacted document appears. Lo and behold, I guess this exhaustive search, they were able to find it. Gentlemen, it's unacceptable. It really is. Now, to learn more, we asked about a certain series of memos when it came to the 809 contract. You all found that was a breach. The treatment of the contractors for the 809 contract, they were treated more favorably, absolutely, compared to my clients. We asked for 3 specific memos that were listed in what was called the Acta de Circunstanciata, or Acta Circunstanciata. True, Mexico gave us the cover memos. False, that they gave us the whole document. I went through this with you all, and I really think it's important. I would like it memorialized. We had to use Mexico's transparency request system to obtain those documents. Imagine if you're in our shoes. I had to take self-help and go find documents that you ordered them to disclose. Even then, what we got was redacted. You send it, and we now know, now that Mexico has disclosed one document that it was required to disclose, we now know what Pemex was hiding behind the curtain. I presented to you an economic model based on a number that was woefully undervalued with respect to the 809 contract. Read it. It was all behind the curtain. The Integradora in Zapata, the 809 contractor, submitted a request or made a demand to Pemex, and they valued a daily rate for not requesting work for their equipment sitting idle at $73,000 a day. We went through, 4 years of this arbitration thinking the true number was 42. If there's anything that I've learned and been able to show those who are coming up behind us, don't do this. Do not engage in this kind of conduct, because it's not okay. It has wasted a lot of our time. Now, if you thought that's bad, I want to go back. In addition to currently, we're being denied documents to help our case in this arbitration. We currently have a claim against the Durama bond of $41.8 million. We just learned, and I'll explain to you in a second, in Mexico's counter memorial, there's another claim that Pemex is making against my clients in Mexico for $9 million in attorney's fees. Make it stop. The torment has to stop at some point. And when I come back later and conclude with you, I'm going to explain to you, I really need you to focus on how you craft your award, because my clients need protection against this. Because I don't think it's going to stop unless the three of you put an end to it. So, in addition to all of these claims, I'm now presented with a counterfactual, or in the counter memorial, this argument. And I've never seen an argument like this, where we take a contract and we strike out words, delete words, add words. And for me, the kicker, we look at documents from before the contract ever even existed to impute language that no one ever contemplated. Why is that important? I had to ask your permission to present some additional documents, and we're going to go through them, like I said, laboriously. It's all a fiction. Pemex doesn't even believe this. You'll see how they understood this contract. And yet you have the government of Mexico coming in here and telling you something completely different. It may explain, perhaps, why we don't have any witnesses from Pemex. I don't know. But I can rest assured, when we sat here, a year or two ago, all we talked about was a minimum amount and maximum amount. And we were talking dollars. 168, 418 million. No one, including the quotations I've seen about my questioning, no one was talking about well counts, whether those well counts were monthly well counts, yearly well counts, in the total of the 1,402-day term of the contract. No one. Yet we're confronted with, again, needless argument about something that's relatively straightforward. And I just look back on it, and I see a number. It's a bit insulting. It's a bit hyper-aggressive. When I get a counter memorial that says, really, thank you for coming and investing in Mexico. Thank you for buying all these rigs that you had to buy and the equipment that you had to buy, doing the work for a year, helping us produce oil that has brought revenues to Mexico. It is beyond insulting to sit there and say, well, you're only entitled to $2.75 million for the balance of the contract. Meanwhile, in Mexico, my clients are being hunted for over $50 million. It's not okay. You don't do this to investors. Now, you'll see Mexico's entire argument is based on a fiction. Pemex would tell you if someone was here from Pemex to tell you, but you'll see it in the question and answers. I've highlighted them for you and we'll go through them. Pemex repeatedly told the bidders, don't worry about the volume of work. We're paying the minimum. That was the guarantee. That's what the concept of what's called an open contract. And we're going to have to go through that. Straightforward, but again, we have to fight. So, at bottom, I look at this, and we're going to go into the 821 contract in a second, and then the 809 contract. But I look at what I've been presented by Mexico and its arguments, in both its counter-memorial and its rejoinder. You all found that Mexico breached the NAFTA in at least 5 different ways. But at bottom, Mexico is contending, and the reality speaks, we're the ones that are going to end up paying. You can't be serious. It's truly one of the more unserious arguments I've seen. Worse, in Mexico's counter-memorial, it devoted several paragraphs to how it was entitled to its costs and fees. I can't believe you can make that kind of claim, considering the reprehensible conduct we've witnessed and the sheer disrespect it has shown to your orders. You shouldn't have had to send several orders about its disclosure obligations. So, what are we going to be asking for? Or what have we asked for? I look at it, both Pemex and Mexico now have tormented claimants since 2016. That's when the bogus work order came around. And neither has shown the ability to restrain itself. It needs to stop. And I'll be frank, I'm not sure monetary relief is going to be enough, because I'm concerned once you put your pen down or hit the send button or however the award is issued, we're going to have yet something else. They need protection from you. And I hope you carefully draft the award, and I'll remind you of it at the end of our opening. So going forward, now that I've gotten that off my chest, we're going to talk about the 821 contract, followed by the 809 contract. It seems to me for the 821 contract that both sides agree that one of our losses should be measured by the value of the 821 contract. We just have a disagreement of how to calculate that measurement. After I talk about the 809 contract, well, let me just explain to you first. While I'm talking about the 809 contract, I'm going to walk you through the new information we just learned about the true rate that was contemplated for the 809 contractor, which was $73,000 a day, not $42,000. After I finish with the 809 contract, Mr. Porter is going to come up and talk to you about your breaches and tying your breaches to our loss calculations. And our loss calculations are straightforward. It doesn't require, with respect, any special expertise. After Mr. Porter, Mr. Browndorf is going to come up and talk to you about our other damages that stem from the unilateral finiquito and the opportunities that Pemex denied my clients by proceeding in that fashion. As just as a reminder, when this arbitration started not long after you were constituted, we tried to stop the unilateral finiquito. We tried to prevent this from certain things from happening. You made a decision, which is fine, that you'll handle it on the back end. Now's the time to handle it. Because Pemex has used this unilateral finiquito to continue to torment my clients. And I learned, making a claim on a bond, by the way, it effectively bars you from getting another bond. No one wants to do business with you because you have a claim against you. And for me, that just compounds the egregiousness of what has happened, especially when they were told, stop it. Please, just hit the pause button. Let's get this arbitration over. But I'll let you determine the appropriate relief for that kind of conduct. After Mr. Browndorf, I'll come back through and briefly talk, and I really mean it briefly, because I find no basis in it. Mexico's lost profit calculation. Now I'll tell you, the only way you're going to be able to adopt Mexico's theory about lost profits is conducting some type of contractual sophistry. You're going to have to invent something. That's the only way I can get there. Because at bottom, in that contract, and we're about to walk through it, Pemex committed itself to at least the minimum amount. And it certainly, and you'll see it, Mr. Porter's going to go through it with you, it definitely created the expectation that claimants would get paid that maximum amount, which is $418 million. Now let's talk about the 821 contract. And let me get my water. So, like I said, the parties effectively agree that one of claimant's losses should be measured by the value of the 821 contract. The problem is we disagree of what that measurement is. We actually look at the words of the contract. You don't have to go far. It says it. There's an obligation for it to spend at least the minimum amount, $168.9 million. Meanwhile, Mexico comes in and says, well, no, despite the plain language, there's really no obligation to spend. In response to, Mexico also adds to its argument, says, well, actually the obligation is to only drill 42 wells. Surprise. To drill 42, and I laugh. I'm trying to be respectful for the argument. I really am. But they say, surprise, the only obligation for Pemex is to drill 42 wells over a 1,402-day period. That's approximately one well per month. You don't make investments like this to drill one well per month. You don't have 10 rigs waiting to work for one well a month. We look at the contract and we're going to show you what the contract says. These numbers are there for guidance. They're only there to protect the contractor from when Pemex starts asking for work. The contractor can't come in and say, we don't have the equipment to request it, or to perform it, excuse me. Nothing more. Mexico starts its argument based on this. I've never seen this document until I saw the counter memorial. And I can tell you I've looked at a lot of documents in this arbitration. According to Mexico, this is Exhibit C-162. R-162, excuse me. According to Mexico, this is proof positive that the obligation under our contract was only to drill wells, 42 over a 1,402-day period. This is slide number 4. I don't know where this document came from. I've not seen it before. I'd love to know I'd love to know more about it. Perhaps we'll hear. But what I can tell you from this document, Mexico is very meticulous when it comes to assigning numbers to contracts, numbers to letters, numbers to memos. You've all seen them. I've highlighted what's missing from this document. You see those X's right under public bid? Best I can take it, this is a draft. So, unless proven otherwise, which there's no one here from Pemex to tell me differently, this is a first. I've seen someone try to make an argument totally contradictory to the plain text of the contract based on a draft document that my clients never even saw. I'd like to point something else out to you that also seems to get overlooked here. There were 10 packages in this diagram. In the bid, there were ultimately 8. Again, we're using a document that's invalid. But it gets worse. You know, this is the chart that I was explained in one of Mexico's memorials that this shows these are a total number, because look, they broke it down by years. How many years are on this? That would be 5. How many years are you going to see in the bid rules? That would be 4. How many years in our contract? That would be 3.8. The other remarkable thing I notice about, again, they don't pay attention to the details. Look at the top right corner, top left corner above package 1. The graphic there says conventional and unconventional. Best I can glean from this document, Pemex had a plan to have 10 packages. Here they're talking about 5 that were going to be performed over a 5-year period, drilling both conventional and unconventional wells. Not our contract. I asked to see the model form. I don't have this document. I asked. I was told, well, you didn't make the proper discovery request 4 years ago, so we won't show it to you. So I can only imagine that that model contract that Pemex had that accompanied this draft of DT1, very different than the model contract that we signed. And the reason why I feel somewhat comfortable saying that is because I've given you the snapshot of our model contract used. It was revision 6. There were 6 iterations before what landed on our desk to make the bid. Another thing that I thought was striking that Mexico doesn't want to talk about, again, like I told you about the equipment requirements under this DT1. This is a proposed Annex DT1. According to Mexico, they do tell us in their rejoinder, paragraph 12, they know it's dated August 2013. There's no date on the exhibit, so they have special knowledge that I don't have. I have to take their word for it. It talks about the equipment and what the equipment requirements were going to be and how they were going to measure the availability of the equipment based on the timing of entering into the contract. Once again, very different than what our contract ultimately was. What's reality is that on August 29, 2013, Pemex tendered the contracts out for bid. And I noticed, and I highlighted it, not to be obnoxious, but to tell you, see the license, see the bid number? I purposely highlighted it because at this point, they actually were proceeding forward. They didn't have that in one of the sole pieces of evidence that Mexico relies on for its argument. When they tendered it out for bid, it was 1,454 days. It was ultimately reduced to 1,402 days. I suspect it was the timing of when the bid was done and then negotiating and evaluating the bids. Along with the tender, there was something called the bid package and the bid rules. And I think these are important because you're going to see our contract tells you, to the extent you have any confusion about our contract, look at what happened at the bid package or in the bid round, the clarifications that were made. We don't look to documents that never existed. This confirms and actually refutes Mexico's sole piece of evidence for its novel theory. It says we're now eight packages, 8 contracts. And they decided to group them at this point, 3, 4, and 5. We were package 5. That would become the 821 contract. Section 2.3, there it is. Open contract. I had to bring this to your attention. And there's a reason why the word open contract is important, and we're going to see it. It's the first 2 words of the 821 contract. That seems to have been overlooked by a lot of us over the past 4 years, but it's really important. I highlight here about the type of the contract, the last clause. It tells the bidders, everybody, there will be a modification process through these clarification meetings. I call them Q&A meetings for shorthand. That there will be a series of Q&A meetings that are some clarifications, and so the contract's going to progress. 2.4, notice we're now at 4 years. That means their sole exhibit and support is now obsolete by the time these bid rules are issued. The 5th most important thing to Pemex when issuing these bid rules was giving everybody the estimated amount. You're not going to find any well count in what people were bidding for and what bidders were submitting bids for. All you're going to see are dollar numbers, both in pesos and US dollars. As I explained to you, the bid rules also talk about the pre-qualification meetings, and there were some post-qualification pre-contract meetings where, you would go into a data room, I would imagine, it's the process or whatever specifics that people would ask questions. What do you mean by this? What do you mean by that? Explain to me this. What are the requirements for that? They tell you in the bid rules, those are all going to be recorded. You need to take them into account when you're making your bid. Now, why do I take a tangent? I'm going to show you clause 30 of our contract. To the extent it wasn't clear, we're not supposed to be looking at a version of Annex DT1 that doesn't have X's on it, doesn't even have a bid number. It says it in the first sentence. We don't do this. But it does say, if you have any confusion about what we've agreed to, we do recognize the importance of the meetings that we're going to have for clarification during the contract process. So let's look at those. This is, I won't go through each detail, but this is the first one. This is the first clarification that Pemex made. As you can see on the left, the equipment schedule completely changed. Very different than what Mexico's exhibit has. I invite you to ask them why. They also explain, apparently the system changed. And you notice, and we've wrote to you in our memorandum, it says it. For packages 1, 2, 3, 4, and 5, Pemex clarifies that according to the estimated ranges of the number of wells to be drilled and completed per year. I highlighted per year. I should have also highlighted estimated because I think that's also important. These aren't real numbers. These are to give you a heads up about what you should be expecting under this contract so you can't complain if you start getting more work than your equipment is prepared to perform. It's not complicated. We weren't alone. The other two regions, again, the packages were broken out. Packages 6, 7, and 8, and 9 and 10, same language. We clarified that the estimated ranges for the number of wells to drill and complete each year. Yet they're coming in here and telling you that it's a total amount of well numbers. Really? Here's some Q&As, some clarifications that Pemex made along the way. This bidder, Pemex, please tell us what's going to happen if you don't comply with the requisite activity for the minimum number of wells. What does Pemex say? Don't worry. My word's not theirs, obviously, but don't worry. Pemex is only obligated to the minimum amount of the contract. This bidder wanted to know how it would be compensated when the minimum number of equipment required to perform the work is reduced because of Pemex made that decision. What did Pemex say? Don't worry, it's an open contract, and we're going to have to look at what an open contract means, and we'll get to it. This bidder asked Pemex request a minimum number of drilling rigs per package. Could you clarify us in order to guarantee us the continual operation of these rigs? These rigs have a value when they sit idle. Once again, Pemex says, don't worry, this is an open contract. When I read it, Pemex is telling the contractor, if your rig sits still and don't have revenue generating work, you're going to get paid the minimum amount of the contract. That's what it says. Here, the bidder says, apparently there was some confusion with the maximum number of wells that were planned to be drilled in NXDT1. And this contractor was concerned and said, could you clarify what the minimum number of wells drilled per year in each of the packages? This bidder clearly understood the deal. It understood that it was a per year. What did Pemex say? Once again, don't worry, it's an open contract. For this reason, volume of wells to be drilled is not considered. PEP is not obligated to drill a specific number of wells per year. It is only obligated to expend the minimum amount per year. Similar question, similar answer. This bidder was worried about, guys, what if our equipment is sitting around waiting, not generating revenue? What happens? What did Pemex say? Don't worry. The volume of wells to be drilled is not considered. PEP is not obligated to drill a specific number of wells per year. It is only obligated to exercise the minimum amount of the contract. There's more. In another meeting, this bidder wanted to know, we understand you have a minimum number of drilling rigs per package. How do you guarantee similar questions before, how do you guarantee the continual operation of these rigs? What did Pemex say? Don't worry, it's an open contract. Pemex is obligated to exercise the minimum amount of the contract. This bidder, was concerned about the quantity and volume of work associated with the line items in Annex DE2. What did Pemex say? Don't worry about it. It's an open contract. There is no specific volume. It continues. This contractor, apparently this was getting late in the process. Remember, it was starting to be 5 total years and then 4. This was getting apparently late in 2013. This bidder was concerned, what happened to the wells that you're estimating to be drilled in 2013? Are those going to carry forward to 2014? What does Pemex say? Once again, it's an open contract. It does not consider volumes. PEP is only obligated to execute the minimum amount of the contract. Because of the concern this bidder presented, it made some adjustments to DT1. This is the same, and I know I'm beating a dead horse at this point, to use an American expression, but this is important. You haven't seen this before, and it completely undermines everything you're going to hear this afternoon from Mexico. Here's one in December. I thought was interesting too. This is getting more particular about page 5, which I think is where the infamous diagram is located in DT1. This bidder wanted some clarification because the maximum wells per package, there were differences in what they were seeing in the documents. What did Pemex say? Guys, these are estimates. They're telling you they're not. This bidder wanted an update of the maximum wells to be drilled per year in Annex DT1, and they also wanted some clarity on the minimum number of wells committed to be drilled per year in each of the packages. Pemex says, again, look, these are estimates. They're indicative, not limiting. Same thing with the minimum and maximum amount. This bidder wanted to know, hey Pemex, are you only obligated to execute the minimum amount? What Pemex says, read the contract. To them, it speaks for itself. But unfortunately, you're not going to have anybody from Pemex here to confirm what I told you. I don't think you need one. You're just going to hear argument. What can we glean from this exercise? And I appreciate it was tedious. The 821 contract was what was called an open contract, like I told you, the first 2 words. Pemex was providing estimates of work to be conducted per year. That's what everybody understood, and that's what the contract says. The volume of the work performed each year did not matter, and I think you heard that from one of the witnesses of the last hearing, right? If you recall, go back and listen to day 3, I think it is. They'll tell you, I think, Mr. Conte, you might have been the one that asked it. You know, what happens when you ask for work at the end? Like, well, just pay the minimum. The volume of work performed during the term did not matter. What mattered was the minimum amount. Now, I will tell you, I've read a lot about now, we should disregard the contractual language because a Mexican civil court issued what was called the TUCMA judgment. And I'm sure you're going to hear exhaustively about the TUCMA judgment. I welcome the TUCMA judgment. I don't run from it. I questioned it at first. I won't lie to you. I questioned it at first because How could a judge come up with that ruling? I started looking at the judgment and thinking about, I used to work for a judge, thinking about what was going on at the time that this case was presented. You all know the facts. Mr. Kernian was told by someone in Pemex, you should file a lawsuit to get Pemex's attention to start issuing work orders. Kind of do it. He did it. It didn't have the reaction that was anticipated, unfortunately. But we filed the lawsuit in the middle of the term of the contract. And what does Pemex say in defense of this lawsuit? Plaintiff is improperly attempting to collect the difference of the minimum amount agreed that has not yet been earned and which corresponds to work that it is obligated to perform. In other words, we were attempting to collect on amounts without performing the work. So I thought about this, again, with my experience looking at cases coming before a judge. The judge is taking that into account. If there's not something specifically in the contract that lets the contractor collect the balance owed mid-term, the law's not going to provide you that remedy. I wish the judge had articulated his logic in that way, but he doesn't say what has been represented. I'm assuming it's a he. I'm sorry if I'm misgendering anyone. They explain. The judge recognized that Pemex was obligated to the minimum, never said Pemex wasn't obligated to the minimum. The sole issue before the court is, can you collect the difference? And this explains the last paragraph that I've highlighted. The judge recognizes that, the parties had agreed to this, but there's no contractual provision that allows me to give you the relief that you're looking for, contractor. In other words, you still have time on the clock at the 1,402-day term. I don't know, but I suspect if my clients had brought this lawsuit on day 1,403, the result would be different. We're back to the bid package, the rules, and I'm going to go through these somewhat quickly, but there are some things I want you to take note of. There's something called a DE2, DE is for the economic annexes, DT are for the technical annexes. For DE2, it's a price list. I agree with FTI, there's a price list for the contract. It's not complicated. The prices that our clients were required or submitted were required to include all costs, financing costs, profit, everything. On the left is Pemex's form, on the right is how we filled out the form. They took those prices and filled out something called Annex DE3. It would become Annex DE3. And Annex DE3 is the catalog of prices for the wells. Remember, if you go and look at Annex DT1, there were, 39 different well types? Yeah, 39 different well types. That would be later expanded in one of the memorandum for 5 or so additional types of wells. They basically had to set prices for the wells that Pemex might request under the contract. What I find illuminating is the last paragraph. Doesn't matter what you put in for these numbers. Ultimately, we were the winning bid at $388 million. What mattered, what was provided in Section 3.5. And we saw Section 3.5 earlier, but I'm going to show it to you again. Go back and it says, whatever you put in this document DE3, which will become Annex DE3, don't worry about the number you're giving us for the dollar number. Look to Section 3.5, the estimated amount. We're not talking well counts. We're talking dollars and pesos. So ultimately, like I told you, we bid $388 million, and because of certain rules that you can't win more than one bid package, we won. In the evaluation process, again, not to beat a dead horse, Pemex reminded during its evaluation, okay, these numbers that we're putting up of all the bidders, you see Schlumberger bid 200 and, I don't know, close to 300 million, all the way down to whatever that last company is that bid 650 million. You're not bidding those kinds of numbers to make the kind of lost profits that is being suggested to you. But what did Pemex remind? Said, we understand these numbers, but you can't hold us to these numbers. What rules is Section 3.5, the estimated amount. They're not talking about number of wells, they're talking about dollars and pesos. So great, we were awarded the 821 contract. I gave you the relevant portion. Look, it's Exhibit C-173, peruse it. You're not going to find anything about well numbers. Per year, per term, nothing. All you're going to see are dollars and pesos. It's what everybody bid on. Same thing when Pemex made the public announcement. Dollars and pesos, not well numbers. In the public announcement of the award, when Pemex said you won, they reminded the winners that they had to submit a bond. That would become that is the Durama bond. And again, I think it's important that the Durama bond is 10% of the maximum amount. That wasn't an arbitrary number. They chose the maximum amount. Why? Because they expected to reach the maximum amount. Why else would you guarantee performance? There's been argument about, I really don't follow it, but the argument is made about the Durama bond. I'll briefly walk you through it. Drake Finley was one of the parties that was a party to the Durama bond. Who is Drake Finley? It was formed in February 2014. The original ownership was 50-50. Finley, Drake Mesa, Mexico. The purpose was to perform under the 821 contract. Later, Price became the owner of 80% of Drake Finley. Why is the Durama bond important? And Mr. Browndorf is going to go into more detail about it, but I'm going to preview a little bit. Our clients are at risk. The Durama bond, again, it says, look, we're guaranteeing the performance of Drake Mesa, Drake Finley, and Finley Resources as joint and several obligors under the 821 contract. I find it interesting, too, that even Durama understood that this contract was worth $418 million. If you look at the fine print, which we need to do as lawyers, if Durama pays, Durama becomes subrogated to Pemex's claims against us, and we pay Durama. That's how the law works. And the contracting, to the extent there was confusion. Now, they did submit the guarantee, the Durama bond. That's a clause 10. Pemex recognizes it. Recognized it so much that it confirms that it was 10% of the maximum amount of the contract. The maximum amount is important. I brought up to you in one of our briefs the importance of the concept of an open contract. First two words. What's an open contract? It's not in the Pemex law. I will agree, one of the few points of agreement with Mexico. I will agree that you're not going to find the definition of an open contract in the Pemex law. But you will find it in something called the Acquisitions Law of 2009, which state entities did use. I'm not saying that they were completely subject to it, but it was there. Not coincidentally, that law explains exactly what our contract was. That a state entity can enter into a contract based on a budget. The minimum budget has to be 40% of the maximum budget. Also not coincidentally, subpart 2 says if you do this, you need to have a corresponding unit price list. I brought back up from the bid rules. You can do the math. It's 40%. The numbers check. I would say it doesn't check when you do well volumes, if you do the math there. Pemex didn't really see it that way. Some important declarations. Again, and it ties back to Mexico's conduct in this arbitration. I want to remind you that in section 1.4 of the contract, it starts by telling my clients, Pemex received all the approvals. What's one of those approvals that Pemex had to receive in order to enter into the 821 contract? Board approval. For the board to approve, what did it have to receive by law? A budget. What have we not seen to date, despite 4 years of pleas and no budget? It has to be bad. That's the only conclusion I can draw of why I haven't seen it. I bet it says $418 million. I think it's safe to assume at this point. And they tell me in section 1.5, we got the funds. We're committed. That means got approval from the legislative branch for up to $418 million for this contract. Now this is the proverbial rubber hits the road part. English expression, American. Clause 5. This is the obligation. This is the one obligation I can definitely say is in the contract with respect to Pemex. I'm not a native Spanish speaker, admittedly, but I did take a lot of Spanish. And I never thought I'd be debating the future tense of a word and then the hypothetical future of a word. But it says it right here. You all can read it. I've given you the translations, Mr. Pillay. Feel free to ask the Spanish speakers. There's a difference. Pemex deliberately chose to use two different words. To expend, may expend. It's not confusing. If there's any doubt, they repeated themselves in the definitions. Says it again. And I'll tell you, you're going to see the same language effectively in the 809 contract. Because I think you were spot on figuring out that we were treated very differently than how they were treated. The other crux that I want to point out to you on this, the crux of Mexico's argument is clause 45. This is the only clause in the contract that mentions DT1. The infamous DT1 where Mexico claims is a well commitment and the sole obligation of Pemex. Let's read it. The maximum, not speaking of minimums, which is being argued here by Mexico, the maximum volume of work that Pemex plans to execute annually under this contract is listed in DT1. Again, look at the contract. Clause 45 says DT1 is annually. You flip to DT1, you see a number. It's an annual number. This is Contract 101. But if you're confused, look at paragraph 2. It says it's possible that Pemex may go through the maximum. It can assign additional work to what? To the maximum annual volume for each year. Not a total number. And I brought back the interpretation of the clause, the interpretation, because I think it's a helpful reminder. We're supposed to look at clause 41 together with Annex DT1. That's what the contract tells us. We don't get to pick and choose, unfortunately. And to the extent you have any confusion, it also tells us go back to the bid documents. Go look at them, which we won't go back, I promise. We've already done it. Now, remarkably, Mexico tells us in its rejoinder, claimant's assertion that these figures were annual, again, we just looked at clause 45. Claimant's assertion that these figures were annual is not supported by Annex DT1. It's exhausting. So let's look at DT1. This is what they're referring to that they claim is a total number throughout the whole term of the 1,402-day period. But let's look at the equipment requirement once again, which explains this chart or graphic. Here's the graphic. This is the infamous 42 minimum well obligations over 1,402 days. What does their equipment requirement say? You've seen it. This was clarified years ago. Pemex clarifies that according to the estimated ranges, you're not using estimated if there's a commitment, estimated ranges of the number of wells to be drilled and completed per year. Yet Mexico tells you nothing to be found in Annex DT1. This would be a good breaking point if there's a time for a break, if people want to break. I'm happy to keep going.
Yes, I think the interpreters are agreeing to that break. So it will be what, if analyst, a 15-minute break? 15 minutes. So we are ready whenever you want.
Well, welcome back. I'd like to turn to the 809 contract, because again, that's important to your evaluating the damages with respect to your decision that Mexico breached its NAFTA obligation to provide national treatment. Again, I'm not going to, I don't think it's productive to relitigate what you've decided. What I want to show you, though, trying the continued quest to try to distinguish the 821 contract from the 809 contract is just not supported. I brought some relevant portions here for you. Look at the first two words of the 809 contract. Open contract. Same concept as the 821. There was a slight upgrade, I guess, from the 809 to the 821 with respect to Clause 5, but the definitions are the same. They understood it. I think everyone in Pemex understands this. They will spend the minimum, and they may spend up to the maximum. Ever so briefly, we know that Pemex had paid $8.4 million more or less under the contract. We know that the contractor claimed the balance of the $24 million minimum. And it's pretty clear what the contractor's position was, that Pemex had failed to issue work orders up to that amount. So they're entitled to the difference. They thought about it. Ultimately, we've come to learn some additional information, and I won't belabor our hearing that we had a couple of weeks ago. Here, the commercial area is sending to the Department of Costs a request saying, I need your help to approve certain prices that we're going to award or give to the 809 contractor. Now, this is post finiquito, after the termination, and I use the word termination lightly, after the end of the works of the contract. Attached to this memo was supporting documentation for the amounts claimed by the contractor. When we submitted our briefing, we were working with Exhibit C-182. And this is the support from the contractor that I just referenced. This is page 74. The contractor explains, we've looked at it, and we are making a claim for the economic effects of lost time due to lack of work assignments by Pemex, and include a little table that we got that was redacted. This is what Pemex, and frankly Mexico, didn't want us to see. That the 809 contractor saw the value of its well sitting idle at $73,352.73 a day. There's another important part of this request from the 809 contractor. It's the last paragraph. You all can read it, but what the contractor is telling Pemex, that they really don't want to fight. They're willing to take a haircut if necessary. Let's negotiate. If you pay promptly. Okay, so maybe Pemex had drawn out the battle for so long that the 809 contractor relented. Attached to the contractor's letter was, again, another chart that broke it down. All the payments. Now this, I can't explain the difference of the rates. Here, the 809 contractor used $73,783.14, which is slightly different than what it put in the body of its letter by dollars. I don't know. I can't explain it, but it's $73,700. Now, also part of the memo, again, we started with the memo that had the attachment of the contractor's letter. Also attached to this memo seeking approval was a table that you all saw in redacted form earlier when we had our previous hearing on this. Well, I haven't shown you the redacted version, but I will tell you the numbers were redacted and what was highlighted was definitely redacted and what I've blown up. Here, Mr. Marfield, who we had a discussion over a couple weeks ago, he signed off when submitting to the Department of Cost this table, and his table is entitled Waiting Time for Lack of Assignment of a Work Order. And look at what he did, how he did his calculations. And it may be better to look at it in C-182 than here on the PowerPoint presentation, but he looked at all of the unit prices for the 809 contract, for all the work that was related, and then what did he add to it? He added indirect costs, field indirect costs, financing costs, and profits. Yet Mexico is here telling you we're only entitled to profits, lost profits. That would, by definition, be treating us less favorably than the 809 contractor. In, I would say, remarkably fast response, this seemed like this was going pretty quick if you look at the dates. We have C-184, which is the response from the Department of Costs. In that memo, it explains they've looked at it. You've included all the items corresponding to materials, labor, machinery, and/or equipment, as well as indirect costs, financing, profit, and additional charges, all inclusive. And they give the thumbs up. Now, the one thing I can't explain, I can tell you that the 809 contractor and Pemex both agreed to a $73,000 a day rate per piece of equipment. I can't tell you how they went from both sides went from 73,000 to 42,000. I suspect there's some documents out there somewhere, but they went to 73,000. But it is not hard to gather how that happened when you add up all the numbers that were ultimately paid to the 809 contractor. As you correctly noted, the 809 contractor, and we'll see Mexico actually admits, the 809 contractor was paid at least the minimum amount of that contract. I wasn't in the room, but I suspect they got from the 73 to 42 by doing the math to where they could get to that minimum amount.
You would say that they, per your case, they re-engineered the price down to 40,000 to match the minimum amount?
Two factors. One, there was a willingness to go downwards because the contractor wanted to get paid expeditiously, and two, I have no reason to dispute, and I bet there's a document somewhere that would say that they engineered this number. Yes. Now, what's important about this number? Look at what they included when they came up with it. They did similar process as they did with the $73,000 number. Did certain numbers, cost items, and then look what they added to it. Once again, indirect costs, field indirect costs, financing charges, 10% profit, and additional charges. We know what happened. We've gone through this before. You've already looked at this. Ultimately, Pemex paid the 809 contractor the balance. It's just not that complicated. Now, I do want to address a couple of arguments that I saw that Mexico made. This is one of them. Pemex didn't pay for all of the idle days that the 809 contractor was demanding. True. The contractor had demanded payment for 118 days between the period of January 1, 2014 and April 28, 2014. What Mexico doesn't tell you is why Pemex rejected that. You'll see on the right. The work was over under the contract. It's not hard. The contractor was asking for more than what it was entitled to according to Pemex, and so Pemex took out the 118 days. Mexico also argues about the equipment. 809 contractor supposedly had 3 drilling rigs. I don't think they owned it, but there's nothing in the record about that. But I can tell you, I don't think that they owned any of them. Nonetheless, it doesn't matter. What I can tell you is all of our 10 pieces of equipment were ready, willing, and able to do work under the 821 contract. Not only as originally agreed, but as you'll come to learn, as expanded under Memorandum 3, 4, and 5, which included different areas of the country. There was work to be done, and they could have done it. And here we go. Mexico doesn't want to talk about these memorandum, for good reason. They came about shortly after the contract gave birth, if you will. It wasn't long. I suspect Pemex, when they wanted to do additional work, they were trying to reach the minimum amount, but that's just me guessing. What's important is the areas of work were expanded, the types of work were expanded. We've shown you, in fact, they had a different price list for some of the work to the tune of $5,600 an hour to use a rig. And I invite you, to the extent that we want to debate about drilling rigs and workover rigs, I saw that argument too. Ask your questions from Alan Claiborne. He's worked with both. He can tell you that our equipment could have been used to perform work under our contract. They were ready, willing, and able. It was Pemex who made the choice only to request work from what's called the PMX 805. We had no control over it. Pemex issued work orders, not us. Again, I'll look at memorandum number 5, just to give you a flavor of the type of work that Pemex was telling our clients was available to do with their equipment. It lured them in. It told them, look, there's 462 operations that are available for you to help out with. That's a far cry from 42 wells that were being told was the actual contractual obligation. The one thing I did notice as well on Memorandum 5, and you'll see it in the other memorandum when you look at them, there's something called a budget availability statement. And the reason why I don't want to beat a dead horse about this, there's a document out there within the internal records of Pemex about the budget for each contract. They have it. If we had that document, I would give it to you and be able to show you what Pemex truly saw the value of this contract. It's there. Now, I'm going to now hand it over to Mr. Porter, who's going to proceed and talk to you about the breaches you found and our losses that are associated with those breaches. Thanks.
Thank you. It's an honor to be back in front of you today. It's also an honor to be back on behalf of Mr. Finley, Jim, and Luis and their companies. Jim and Luis went to Mexico with the intention to create a long-term beneficial relationship with Pemex. And your decision found that they were treated unjustly, vindictively, and in violation of the NAFTA protections. The decision was the first time that Jim and Luis were vindicated for what happened to them in Mexico. And soon after receiving that decision, we went to how to turn that vindication into valuation of what they lost. We turned to valuing the losses that occurred based on these breaches. These are the breaches that were found in the decision. And we based our loss models that you're going to see on these breaches to be causally attached to them. And we will show based on these breaches that claimants suffered losses such as the value of the 821 contract. But it's not just losses that claimants have suffered in the past, like the value of the 821 contract. As Mr. Melsheimer has talked about today, it's losses that are currently happening today and things that need to be accounted for today. For example, the decision to continue calling on the Rama bond, which was specifically a breach found in your decision. If you read that last bullet point there, this tribunal found that the unilateral finiquito and the calling of the Rama bond were breaches. And we'll tell you how to value that breach. Mr. Browndorf will tell you how to value that breach today and to provide protection for claimants. We believe that claimants' losses can be broke down into the following categories. First, and I'll tell you about the value of the 821 contract, and then also the active claims under the unilateral finiquito, losses suffered as a consequence of the unilateral finiquito, and then obviously interest, which is a part of claimants' compensation for their losses. Before I do that, though, I want to address a couple things as it regards to claimants' investments. In your decision, you put forth a question to us to describe investor involvement in the 821 contract. And when that question was raised, we're going to rise to the occasion and we're going to answer those questions and provide even more evidence and even more testimony, and we've done so. We've brought more people. Mr. Melsheimer mentioned, and you've seen Mr. Claiborne already, and Jim and Luis are back here today to talk about the companies and how they made the investments in Mexico. But first, to understand the investor involvement in the 821 contract, we need to look at what the NAFTA and how it defines what an investor is. Under the NAFTA, investor status is based on the place of incorporation for a company. It hinges on that. The NAFTA defines an investor of a party under Article 39 as a state enterprise or a national enterprise of a party that seeks to make, is making, or has made an investment. And an enterprise is broadly defined as any entity organized under applicable law. And what that means is the plain language of Article 1139 does not require an examination of an enterprise's ownership. A company such as Finley or Price, they can qualify as a U.S. investor based solely on the fact that they're organized under the laws of the United States. I think I can further put everyone at ease. Finley and Price are organized under the laws of the United States, and they own and control every investment under the 821 contract. Finley Resources owns and controls Drake Finley. Price Permanent Holdings owns and controls Drake Mesa, and it owns and controls Drake Finley. And we'll talk a little bit further about the investments that those companies made. Also in your decision, you stated, the tribunal sees merit in claimant's assertion that concerning the 821 contract, Finley committed significant capital and other resources by importing workover rigs and drilling rigs. You also say the tribunal concludes that the claimants committed resources in Mexico, which qualifies as investments. Despite this, we continue to get questions from Mexico about who actually owned these rigs. It's a novel theory. I don't think people just let you use their rigs, okay? And you can ask Mr. Claiborne about that. These are high-dollar pieces of equipment. You have to own or control them if you're going to be drilling holes in Mexico. And if you go back at the time Pemex was not raising any questions about who owned and controlled the rigs and whether they were where they were supposed to be. But again, we brought everyone again. You can ask them the questions about the rigs. This was the equipment, rigs and equipment, that was used and invested and committed to the 821 contract. This equipment, as we discussed before, to purchase it, all capital was channeled through Finley Resources, and Mr. Finley has testified to that, and he'll testify again. And the ownership of the equipment was through Drake Mesa, Mexico, which is owned and controlled by Prize. Let's talk about PMX 805. This was the only rig that Pemex actually requested work from under the 821 contract. And just give you a little bit of background on the PMX 805. It was purchased in July 2013 by Drake Mesa LLC from CC Forbes. And the reason it was purchased by Drake Mesa LLC is CC Forbes, and you'll hear this from Mr. Claiborne, was a public company in the United States, and they requested to do the transaction in the United States. That piece of equipment was already in Mexico doing work for Pemex. Alan Claiborne facilitated that transaction. And you can ask him about it. He knew someone at CC Forbes, called him up, said, we need a new rig, we're doing more work for Pemex. They made that purchase in July 2013. When he went down and he saw the rig, he knew it needed immediate upgrades, major upgrades. You're going to hear him talk about how he went down to Mexico himself with a team of people. And he worked on that rig for a couple weeks to get it ready to perform up to Pemex's standards and the standards required under the 821 contract. Mr. Claiborne is also going to talk about a document here that transferred ownership from Drake Mesa LLC to Drake Mesa, Mexico. He handled all of this process. He handled the process of making sure that ownership was transferred to Drake Mesa, Mexico through this document. You can ask him about it. Claimants also committed 9 other rigs and equipment to the 821 contract. And we've discussed these rigs also. We'll go through it again. They were purchased by Drake Mesa LLC. And they were in the United States. And they were imported into Mexico. And at the border, there was a transfer of ownership to Drake Mesa, Mexico. And that transfer of ownership was memorialized on December 20th, 2013 in a document that Mr. Claiborne put together as well to show there was a bill of sale between Drake Mesa, Mexico, between Drake Mesa LLC and Drake Mesa, Mexico. And Mr. Claiborne, he'll explain exactly where that document came from, how he found it, and he'll also talk about the normal business practices that he has in his business and why there was such a document as this. You're also going to hear from Mexico that claimants actually only had one rig that performed work or was committed to the 821 contract, and that's just incorrect. If you look at Memorandum of Understanding number 3, there's actually a price list attached to it. And Mr. Melsheimer went through this briefly a second ago, but the Memorandums of Understanding, what they really did, it was a request by Pemex to Prize and Finley to move equipment to other places not already underneath the 821 contract, to do more. They are asking them to do more, to expand operations. And when they asked them to expand operations, they knew exactly the rigs that were committed in that contract. And in fact, in that price list attached to Memorandum of Understanding number 3, they list a rig called the Bissell 2. And they put a price on that rig as $5,600 an hour to perform work. And it wasn't just rigs and related equipment and employees that go with rigs. It was a prescriptive list. It was an exhaustive list of equipment that was required by Pemex to perform work under the 821 contract. I'll show you just a couple examples of that, but one of those is, you can see here, a mobile accommodation trailer had to be on site for each drilling rig and completion crew. It had to be equipped with 2 bedrooms. There had to be a personal computer The list goes on and on. There had to be a pickup truck for Pemex's use. And that pickup truck had specific requirements that it had to have, such as it should not exceed 40,000 kilometers of accumulated mileage. And how did Pemex keep up with this? Through constant monitoring. Mr. Claiborne is going to talk to you about someone he kind of referred to in jest as the checklist guy. And he was always there, always on site, always walking around going, do you have this? Do you have that? And checking the box. And claimants never failed that check, because I promise you, I can refer back to Mr. Lucenau's memo. He said in that memo, find me the breaches. There was no breach in that administrative rescission for claimants not having their work, the equipment they needed to perform the contract. You remember some of the breaches that were in that decision. I promise you they would have put not having your equipment there. Also, you're going to hear an argument today or tomorrow from FTI that talks a little bit about how claimants could have used their equipment for other projects or other things in Mexico. They could have taken this equipment and moved it and made money off of it on another project. That just goes against the exact words of what the contract required. And I'll just read it here. The contractor and any subcontractors must not have the tools, equipment, personnel committed to any other contract on the start date of the work and throughout the duration of the contract. From when the works begin and for the duration thereof, the contractor shall be obligated to have personnel, equipment, tools, and facilities in normal operating condition available to PEP 24 hours a day for the work covered under the contract. Now that we've gone through the equipment, let's talk a little bit about the bulk of claimants' losses due to Mexico's breaches, and that is the value of the 821 contract. The principles for determining damages in NAFTA cases. NAFTA Article 1135, it authorizes the tribunal to award monetary damages and applicable interest. And both sides agree that is kind of interpreted by international law standard, and the NAFTA says that as well. And the governing principle for that is calculating damages is full reparation. And this comes from the Chorzów factory case, where damages should, as far as possible, wipe out all the consequences of the illegal act and reestablish the situation which in all probability had existed if the act had not been committed. This is sometimes called the but-for scenario, and you're going to hear that from the experts. You're going to hear that from our side. Mexico sometimes calls it the counterfactual scenario. We have a very simple but-for scenario. Claimant's losses, the but-for scenario and claimant's losses is the value of the 821 contract. That's the but-for. We lost that value due to the breaches of Mexico. Mexico's but-for scenario is slightly more convoluted. Mexico bases their counterfactual on the fact that the 809 contract. They look at the 809 contract and they said that the 809 contractor entered it into a finiquito, and then 3 years later they settled that agreement. So therefore, you should, as far as interest goes, wait 3 years before applying interest. But Mexico fails to take into account that when Pemex settled with the Mexican contractors, they gave them the minimum amount. FTI fails to take that into account. It's ignored. That's not a counterfactual. It's a parallel universe. The NAFTA sole requirement when it comes to damages is that claimant's loss needs to occur by reason of or arising out of Mexico's breaches. You have to tie it back to the breaches, and that's what we've done today. The NAFTA does not address the computation of damages. It doesn't tell you any methodology for how to determine damages. It doesn't say you have to apply lost profits. So this tribunal has considerable discretion in fashioning reasonable approaches consistent with the requirements of the NAFTA. Really what the NAFTA does is it mandates that compensation should be shaped by the specific breaches. And what that does is it ensures that the remedy corresponds to the legal harm. And what we have here, and in this case, is the most reliable and the most conservative way to quantify claimant's loss is to value what the 821 contract would have delivered, its obligations. Anchoring the remedy in the 821 contract's promised returns ties the damages award to the breaches and it affords full reparation. We believe that you can value the 821 contract in 3 ways. We're giving you options. First way is the minimum amount guarantee. The second way is PEMEX's treatment of the 809 contractors, which is PEMEX's value of the 821 contract as well, how they would value it, and the expectations of the maximum amount. First, we'll talk about the minimum amount guarantee, and Mr. Melsheimer has hit this already, but I do think it's important to talk about it one more time. When asked how to value or what this contract was about, PEMEX made the following statement. They were asked, in the event the minimum number of wells per year is not drilled due to reasons attributable to PEP, how will PEP pay for the waiting times of the equipment and other expenses generated by these type of events? PEMEX answered, this is an open contract that is executed through a catalog of unit prices. For this reason, the volume of wells to be drilled is not considered. PEP is not obligated to drill a specific number of wells per year. It is only obligated to exercise the minimum of the contract, minimum amount. That backs up the plain language of Article 5. And I'll allow Mr. Melsheimer and others to have the pronunciation of the verb, and he's also addressed that as well. But in face with this, Mexico argues the 821 contract did not create a guarantee. It did not have a guarantee owed by PEMEX to claimants. And they make the 2 arguments. Es será is merely a permissive verb, and the TUCMA ruling. Based on the TUCMA ruling, this civil court in Mexico that said the minimum amount does not have to be paid to claimants. Now I want to talk about the TUCMA ruling in brief as it pertains to NAFTA damages. To understand the TUCMA ruling, I think you have to put it, the TUCMA judgment, you have to put it in context. The context of what happened. And Mr. Melsheimer talked a little bit about this earlier. First, the 821 contract commenced on March 1st, 2014, and had a term of 1,402 days. By April 29, 2016, we've gone through this. This history has been stated here before. Claimants filed a civil claim to get PEMEX's attention. They were begging them to issue work orders. PEMEX had been trying to starve them out, put their companies out of business, and they filed a claim at PEMEX's direction to try to get them to issue work orders. So these were the facts before the TUCMA court. The facts were there's 611 days remained on the term of the contract. Approximately $120 million remained for PEMEX to meet. For claimants to meet the minimum. And PEMEX argued in that court, in that case before the TUCMA court, that claimants hadn't earned the minimum amount. They stated that plaintiff is improperly attempting to collect the difference of the minimum amount agreed in the contract that has not yet been earned and which corresponds to work that is obligated to perform under the contract. Therefore, they're attempting to collect these amounts without performing the work as excessive and unjustified. They're trying to get paid before their term is up. We're not asking you to appeal the TUCMA judgment. We're not asking you to go and say it was anything other than what it is. Give it the deference it deserves. It was a different legal framework. It was a different factual predicate. There was 611 days remaining on the term. There's $120 million remaining to be completed, worth of work. And most importantly, I think here, and it's something that's critical as far as looking at the NAFTA damages and how Mexico treated claimants compared to Mexican contractors. The TUCMA judgment is irrelevant to the national treatment. You stated in your decision when it came to the national treatment breach, you stated it is therefore hard to see how the Mexican companies and the claimants are not in like circumstances. PEP stopped issuing work orders to both parties However, PEP settled with the Mexican companies, but did not do so with claimants. You see, that settlement, the Acta Circunstanciata, it occurred on April 9, 2018, which was a full year before the Tuckma judgment. Tuckma judgment should have never happened. PEP should have settled with claimants the same day that they settled with the Mexican contractors. You found that date to be a breach in your decision. Let's talk just a second about that settlement too, because it also plays into support for claimants' losses when it comes to the minimum amount guarantee. The Mexican contractors were paid at least the minimum amount. This is not in dispute. Mexico has admitted this in their briefing, that the settlement with the Mexican contractors at least met the minimum amount. That is support for providing the minimum amount remaining to claimants. But it's not just the 809 contractors. It's other contractors in this package, in this area as well. The 819 contract, it had a minimum amount of $256 million. They were paid $298 million. The 820 contractors, they had a minimum amount of $190 million. They were paid $329 million. And if you don't believe me, or the 809 contract settlement, or the 819 contractors, or the 820 contractors, I think a video here of Mexico's own expert, it shows exactly what the obligation to the minimum amount was under the contract.
I think that PEP did have an obligation under the contracts to at least use the minimum amount in the contracts. And this, of course, was amended after the finiquitos were issued.
I'm also going to play one more where he clarifies exactly what he means by minimum amount. And you might hear from Mexico in a second about how he meant actually the totality of the works. Clearly, that was not the case at the time.
You've read the good faith clause, I believe, correct?
Sí, señor.
Yes.
I like to focus on B. As an expert in contracts, what is your understanding of Pemex's obligation under this clause?
Ambas partes debían
Both parties needed to cooperate and consult with each other as necessary to attain the total completion of the works. Clearly, the idea with the signing of the contract was to perform the works contracted within the terms expected and also based on the monies that were to be paid to the contractor.
Portion of this clause. It says the totality of the works. What does that mean to you?
que las partes
That the parties had to see that the totality of the works were completed. I think that it is a natural clause and a regular clause whenever one initiates a contract relationship that is intended to perform or to comply with the object of the contract.
Okay, can you put a number on what totality of the works means?
100%.
100% of what?
los trabajos que pretendían realizar.
of the work that had to be carried out.
And what are those?
Las obras contratadas.
The works contracted, the wells to be carried out, what the parties expected at the time of signing the agreement, the contract.
Is there a monetary amount for this, or a number of well amount, or what?
Ahí lo
I said it in my presentation, there was an amount. I think that the minimum work had to do with $168 million up to $441 million.
Thank you. I told Mr. Melsheimer after I watched this video again that his question was actually clairvoyant, because we didn't understand at the time that Mexico was going to cook up this 42 well requirement in the contract. But he asked that specific question to Asali, their own expert. He asked him, is it about the wells or is it about the minimum amount of the money? He answered. You saw it there. If you take even Mr. Asali's statement that we were owed the minimum amount, and the fact that the 809 contractor got the minimum amount, but for the TFA judgment, claimants would be paid the amount balance of the minimum. But for the unilateral finiquito, claimants would be paid the balance of the minimum. And but for claimants being treated less favorably than 809 contractors, they would have been paid the balance of the minimum. And that unpaid balance is $120 million. That's without interest, and we'll discuss interest later. Now let's talk a little bit about loss model number 2, which is based on national treatment damages. Under the NAFTA, Mexico was required to treat claimants no less favorably than the Mexican contractors. Thus, claimants are entitled to damages that would place them in the position they would have occupied had Mexico honored its national treatment obligation, if they would have settled with us on the same terms that they settled with the Mexican contractors. The appropriate measure is the treatment Mexican contractors actually received, and the claimant should recover no less. I showed you this earlier, but in your decision, you talked about that settlement as being a part of the national treatment breach. Again, the 809 contractor was paid the minimum. This is something that's admitted by Mexico. And if you go back and you look at the finiquito and the acta circunstanciata and the acta de extinción and put them together, you can see that the total they got paid was right at or above the minimum amount. So how did they get there? Mr. Melsheimer talked about that earlier. He talked about that $42,167 daily rig amount that they came up with to get the 809 contract settlement. And that number, as we've seen now, was associated with this list of items. And this was a negotiated settlement amount by Pemex and the Mexican contractors. It reflects what the Mexico determined was a fair value sitting across the table with the Mexican contractors for the value of a rig in the Chicontepec region on a daily rate. And that's what's important. They assess that value, which is what claimants have lost under the national treatment breach. To get the total settlement, they took the days that the rigs were idle under the 809 contract, the 3 rigs. And they took the idle days and they multiplied it by the $42,000 a day rate, and they came up with the settlement amount. The math is pretty easy. You don't need an expert to do this math to treat us just like the national treatment, under the national treatment damages. Claimants had 10 rigs assigned to the 821 contract, committed to the 821 contract. So this is a conservative application of the national treatment standard. We're not asking to be treated better than the Mexican contractors, just treat us just as favorably. So if you take the PMX 805 and you look at the days that actually committed work, actually performed work, and then subtract that by the total amount of days, that's how you get 921 days that it was not idle. Multiply that times 42,000, you get 39 million. Claimant's 10 other rigs never performed work. The Bissell 2 or the other rigs, here rig number 3. You take those 1,402 days, multiply it times 42,000, you get around 60 million. And that gives you $157 million, which would be the value of all those three rigs sitting idle, which Pemex agreed to in the 809 contract settlement. There does need to be a variance adjustment done here. The 809 contract was for 214 days. The 821 contract was for 1,402 days. The 809 contract, the max was 60 million. 821 contract, the max was 418 million. So if you divide those numbers, you will see pretty clearly that Price and Finley had to do more work in a shorter period of time. So it does need to be a time variance adjustment here of 1.068. And if you add that to the daily rig rate, you get $45,000 for a daily rig rate, and the resulting loss for 821 contract is $168 million.
Excuse me, Ms. Porter, could you repeat again the reasoning behind that calculation?
Yeah, so the 809 contract was 214 days long. The 821 contract was 1,402 days. Originally, it was 1,454 days. And so if you divide 60 million, which is the max for 809, by 214, and 418 by 1,402, you're going to get roughly, they're roughly 7, the 809 is roughly, I mean, the 821 is roughly 7 times the 809. But then our contract, either we started late or there was a delay in putting work orders in. The contract started and it was reduced to 1,402 days. So it became a shorter period of time to perform more work. So we believe that it's fair to provide a variance to that daily rig rate to show that we perform more work in a shorter period of time for the amount of value of the contract. And that's why it's 1.068. And you would add that to the daily rig rate. And it's needed because the value is based on the rig rate, the daily rig rate. We also have provided a separate way to look at the 821 contract based on the $42,000 a day rig rate. And this is the way to look at this, is what Pemex would think was the value of the 809 contract based on the lack of assignment of works, and then put that forward to the 821 contract. If you look, you say $42,000 a day per rig, which is 3 pieces of equipment, you get $126,000. That's a way to look at how Pemex valued the rigs sitting idle, what they were worth in the Chicontepec on a daily rate, total equipment rate. And you can give it the same adjustment factor we just discussed, which gives you $135,000 a day. And then you multiply that times the amount of days in the contract, 1,402, and then subtract it by how much work was actually performed, and it gives you another way to look at the loss claimant suffered by not being treated the same as the 809 contractors. Until recently, claimants believed that the value of the idle equipment was $42,000 per day. And new information reveals that Pemex actually valued that equipment at $73,000 a day. They confirmed that. They condoned that number, which is nearly 75% higher than the originally understood valuation. Pemex's own internal valuation demonstrates the true value of the equipment. It's the true value of what they believe the equipment was worth for sitting idle, one rig and related equipment in the Chicontepec region. This is not claimant's number. This is not something we came up with. It's what Pemex confirms. And it also confirms our approach to damages in this case, that it has been conservative from the start. And you can do the math. It's simple to do the same math we just did. And the numbers are going to come out higher because there's a higher value. The number will come out at $273 million if you're looking at idle days based on $73,000 a day. You apply that same time variance adjustment, it comes out at $292 million. If you value a rig sitting idle at $73,000 a day. Again, we had 10 rigs this is only based on 3 rigs. And the math is done the same for the package of equipment. Looking at it totally, if you put $73,000 a day for 3 pieces of equipment sitting idle and subtract with the work that was actually performed, you get $281 million. The key here is Pemex believed that a rig sitting idle in the Chicontepec during this time was worth $73,000 a day. Now let's talk about claimant's legitimate expectation damages. The minimum amount should be the starting point. Claimants were required to make investments and maintain preparedness corresponding to the maximum amount of the 821 contract. Just an example of this, Mexico is currently claiming the USD $41.8 million Durama bond. That is based on the maximum amount of the contract, 10% of it. And Pemex shared this legitimate expectation and imposed contractual requirements on claimants that aligned with the maximum amount. This document in front of you is actually a document that was provided by FTI that they received from Pemex, and is for a work order, the Remolino 2912. And you can see on this work order that Pemex put the value, the amount of the contract at $418 million. This wasn't the only document that FTI put in to support its well count at lost profits amount. Each and every one of them indicated that the contract was worth $418 million. This is on the face of the Pemex documents. Again, this is not our valuation. This is Pemex's own valuation of what claimants lost. This is another work order, another document attached to a work order. This is the infamous bogus or fake work order. You can see, even on the fake and the bogus work order, the total contract amount was listed at $418 million. But critically, it also listed the percentage of amount used as 11.46%, which is based on the total $418 million maximum amount of the contract. It listed the percentage remaining as 70.81% based on the total amount of the maximum amount of the contract. It also listed the amount remaining, $370 million. It's 418 minus the work already performed, which is the last work order, obviously. So they based the amount remaining of the contract on the maximum amount. But what this should also show you is what's really at stake. They didn't issue a fake work order for $2.8 million in lost profits. They didn't issue a bogus work order for what FTI Mexico is claiming are claimants' losses here. They issued a fake work order because the amount of the contract was $418 million. Now, let's talk about interest. There's express authority under the NAFTA with the power to award monetary damages and any applicable interest. Also, under national law, the principle of full reparation says interest must be awarded when necessary in order to ensure full reparation. Interest has also been described as part of claimant's compensation. We could talk a little bit more about that in a second. We have based our interest in this case on the fact that Pemex was giving money in its budget to pay claimants its promised returns. Instead, Pemex failed to pay claimants the funds promised under the 821 contract. Instead, Pemex used that money for other purposes. Essentially, they borrowed claimants' money and used it for other purposes. Thus, the appropriate interest rate is what Pemex or Mexico would have paid in the market for that same money, their borrowing cost. This reflects the true costs that Pemex avoided by withholding payments from claimants. But if you don't believe me, that they used claimants' promised money under the 821 contract for other projects, take a look at this. The acting director general of the PEMEX, PEP, stated in 2014, last year the drilling program was halted in both Chicontepec and Burgos. In Chicontepec, we had a budget problem in one of the regions, something we've discussed here. In order to pay for operations that were done off budget, we had to reallocate financial resources that were originally destined to pay for drilling operations. As a result, we did not drill the planned number of wells in the Chicontepec. Take him for his word, they used claimants' money for other purposes. They borrowed claimants' money. Based on Pemex's and Mexico's borrowing cost, we believe the following is the best format for interest. Interest should accrue from the first date of the breach, which we believe starts on March 26, 2018. And the applicable interest rate should be based on 10-year rates. This is the closest in time to the amount of time that claimants have been owed money. We've given you two different rates, a peso-denominated rate and a U.S. dollar-denominated rate. Both of them are based on what Pemex and Mexico is based on their borrowing costs and what they pay in the market for funds. We believe that interest should be compounded on a biannual basis. We also believe that the post-award interest rate should incentivize prompt payment. We'll discuss that in a second. These are Mexico's position on interest. They believe interest should run from November 10th, 2021, that counterfactual, that 3 years after period. They believe that interest rates should be set at 1.13% simple interest. And they believe a post-award interest rate is punitive. So let's talk about the start date. I found no support anywhere for Mexico's counterfactual start date for interest of November 10, 2021. Tribunals have been clear that interest becomes an integral part of the compensation itself, and it should run consequently from the date when the state's international responsibility became engaged, the date of the first breach. And we believe, based on reading your decision, that the date of the first breach was March 26, 2018. We believe that you found there was a course of conduct that had been occurring, and the first date that Mexico's international obligation became engaged was March 26, 2018. But the latest date that interest could begin running would be April 9, 2018, which was the date of the acta circunstanciata, the date that Pemex settled with the Mexican contractors. Let's talk about a risk-free rate. Mexico has tried before to benefit from the credit risk of the United States and put forth rates based on U.S. Treasury notes. And there's a problem there. Tribunals have told them about this problem. They've told them the U.S. Treasury bond rate does not reflect the counterparty risk, since the debtor is Mexico, not the U.S. In this sense, it seems reasonable that the applicable interest rate should be equivalent to what Mexico pays when it borrows money by issuing sovereign debt bonds. You're going to hear Mr. Manis talk about this a little bit tomorrow. He's going to tell you about counterparty risk, why it's important when you're determining proper interest rates. Also, let's just talk about inflation. 1.13% is lower than inflation, especially since 2021. So what Mexico is asking you to do with a 1.13 interest rate is they're actually asking you to assess an interest that makes claimants lose value on their money that they lost. This keeps up with Mexico's theme, obviously, throughout this arbitration, where they breach the NAFTA and we pay. Simple interest. Compounding is the norm for modern investment products. I think we all know that. And as demonstrated in our briefing, international tribunals and NAFTA tribunals have recognized and they've clearly shifted to awarding compound interest. This is a point that Mexico ignores. But also, beyond those points, When Mexico goes to the market for liquidity, it gives investors compound interest. The two products that we put forth to you today as reasonable products to assess interest, the 10-year Pemex note and the 10-year federal government bond, both compound interest on a biannual basis. Now the post-award interest rate, which is critically important. You're going to hear Mr. Melsheimer go through this again because we believe it is critically important to your award and how your award is drafted. We are asking for a post-award interest rate increase for two reasons. One, protection, and two, finality. Claimants have proposed an interest rate based on Mexico and Pemex's borrowing cost, but that leaves us vulnerable in a post-award interest rate situation. It leaves us vulnerable because if Pemex can go into the market and get a better rate, they have an incentive not to pay. Thus, an increased rate, an increased post-award interest rate, it's not about punitive damages. It's about protection. It's about protecting claimants. If Mexico pays the award, there will be no increase. Also, if you have any question about our concern, or why we would be concerned about Mexico not paying the award, let's just look at Mexico's conduct in this arbitration. First, they filed a request for clarification, which was a veiled attempt to appeal your award. They also continue to acknowledge that in the decision you found the calling of the drama bond and the unilateral finiquito were breaches of the NAFTA. And they still, in Mexico that never happened, and they still are hunting our clients, Jim and Luis, in Mexico for the drama bond. Take that into account when you're thinking about a post-award interest rate. And let's be honest, a 1.13% interest rate leaves claimants exposed. It also fails to bring finality to this dispute. This dispute's been going on for over 10 years in Mexican courts and now in this tribunal. A post-award interest rate can bring finality to this dispute. And once you put the pen down on the award, you lose control over that. Thank you.
Good afternoon. It's nice to be back before the three of you, as well as Counsel for Mexico. I've been tasked today with discussing claimants' remaining losses. The basis for these damages is quite straightforward. In the decision, you found that Mexico breached the NAFTA in at least 5 ways. Here we see 3 of those ways. The Via Hermosa meeting to call the drama bond, the unilateral finiquito in and of itself, and any other actions necessary to or as a result of the unilateral finiquito. All of claimants' remaining losses stem directly and can be attributed to these NAFTA breaches. Tribunal is well aware of the history of the unilateral finiquito. It was issued mere weeks after the 3 of you were appointed, and Pemex acted with great haste to attempt to serve it on claimants. So much so that they arrived at the doorstep of Finley's former attorney in Mexico City to effectuate service. When she informed them that she no longer represented Drake Finley, or Drake Mesa, they returned to her office the next day and taped the documents to her door. Why was Mexico in such a rush? The answer to that question can be found 3.5 years earlier in a different Mexican city. The first NAFTA breach I just referenced is the Via Hermosa meeting. There, Pemex decided to call the $41.8 million Durama bond. A month later, the bond was called. But it didn't work. Durama told Pemex, go get a finiquito. So Pemex waited until claimants dismissed all of their lawsuits in order to pursue this arbitration, and then struck while the iron was hot. A new claim against the Durama bond was made on the date of this tribunal's first session. Sensing the writing on the wall, claimants pleaded for protection through their request for interim measures. For 3 years, claimants staved off Pemex's efforts in Mexican courts. They have monitored and submitted filings aimed at the root cause that enables Pemex to call the Durama bond the unilateral finiquito. Finally, in late 2024, the decision ruled in no uncertain terms that both the unilateral finiquito and the call on the Durama bond themselves breached the NAFTA. Now, one would expect, once Pemex read this decision, it would act immediately to withdraw, tear up, cancel the finiquito. In turn, this would end the related litigation. But as we stand here today, that still has not happened. In the offices of Pemex, be those in Poza Rica or Villahermosa or Mexico City, the decision does not exist. The unilateral finiquito is still alive and well and active, and so too are claimants' losses they're under. Here are the approximate $43 million in penalties that Pemex continues to pursue in breach of the NAFTA. I'd like to discuss a few of these line items. Of course, the centerpiece is the Durama bond itself. As a reminder, the penalty of the Durama bond is close to the total payment that claimants received under the 821 contract. But other losses are present too. The bond includes language that requires claimants to pay Durama's legal fees and costs. These losses continue to mount while the finiquito remains active alongside the related lawsuit. There are also losses that are more difficult to quantify. The 821 contractors, along with Mr. Finley, Mr. Kernian, and their children who are involved with and represent the future of their businesses, suffer the effects of being the target of an active call on a bond in Mexico. One thing is clear from Pemex's conduct. Pemex will get its money. Makes no difference if Durama makes the payment, as Durama will then become subrogated to Pemex's claim. It will pursue what it is owed from claimants, attaching to Mr. Kernian's properties if they are unable to collect the full amount. And as I previously stated, Durama will get whatever fees and costs it has incurred in the related lawsuit. Payment of these amounts to claimants, to then be paid to Pemex or Durama, or both Pemex and Durama, is the best way to finally end this saga. The final award should include these amounts in order to protect claimants from the ongoing abuses that violate the NAFTA and to assure finality. Mexico's two arguments concerning the Durama bond should be familiar, as they're repeated from the earlier phase of this arbitration. First, the tribunal is aware that whether the Durama bond qualifies by itself as an investment is an open question. We stand by our arguments made in that initial phase, and we would welcome a ruling from the tribunal that the Durama bond is an investment. But it's not necessary. The three of you have already found that the calling of the Durama bond itself breached the NAFTA, and claimants are entitled to their damages arising from this breach under the theory of full reparation. Mexico argues that claimants have not proven their relationship to the Durama bond. Again, we see Mexico questioning ownership and involvement with this investment. If the tribunal has any concerns, we encourage it to look to the bond itself, C-178, which is in favor of Drake Mesa, and Finley. Look to the Durama's invoice to Drake Finley for the administrative costs of the bond, C-179. Look to Clause 10 of the 821 contract that requires the bond. To harken back to C-103, Mr. Lustinel's memo, don't you think if the bond was not in favor of claimants, that would have fallen under one of the breaches to impute to the contractor? The next line item I'd like to address is for performance delay penalties. I highlight this to emphasize to the tribunal that $262,500 of these penalties relate to the infamous fake work order. Pemex has no regard for what you've written in this decision. It still maintains an active claim for these amounts. Same story with the next line item, the PACMA penalties. Pemex ignores your finding that PACMA was a false flag for rescission. To sum up these last few slides and this category of losses as a whole, the unilateral finiquito itself is a breach of the NAFTA, and claimants are entitled to full reparation for it. Pemex continues to ignore the decision and actively pursue the penalties thereunder, and the best way for the tribunal to protect claimants and promote finality in its award is to award these amounts as damages. The next grouping of damages follows a similarly straightforward logic. Recall that the decision found that actions as a consequence of the unilateral finiquito also breached the NAFTA. The 821 contract, and I would imagine all Pemex contracts, describes the meaning of the finiquito process. It's meant to allow contractors and Pemex to sit down at the bargaining table and try to work out their differences, whatever those may be. Pemex denied claimants their seat at the table, and as a consequence, they were not afforded the opportunity to raise a number of monetary claims, the first of which are labor-related employment claims. These claims came about because of forced terminations of Drake Mesa's employees. Review of the 819 and the 820 contract finiquitos confirmed that these labor-related claims would have been addressed at this negotiating table. Here are the claims that Finley, Drake Mesa, and Drake Finley would have raised but for Pemex's deprivation. Claimants were forced to terminate a number of employees because of Pemex's conduct under the 821 contract. Payments to these employees continue to this day. And of course, included in these payments are required taxes, paid time off, vacation, whatever Mexico law demands must be paid to wrongfully terminate employees. A number of lawsuits also remain active, and claimants continue to incur legal fees for these lawsuits. The amount listed here has increased since the submission of our damages briefs, and in the post-hearing brief we would update it accordingly. Mexico raises a number of arguments concerning this category of losses. Once again, it questions the relationship between these liabilities and claimants. Mr. Kurnian will be prepared to testify regarding the third party that Drake Mesa hired to conduct human resources matters, these administrative tasks. The mere presence of a company that handles payroll, personnel matters, similar to an ADP here in the United States, does not detract from the fact that these were Drake Mesa employees, and Drake Mesa bore the ultimate consequences for their terminations. Mexico, and FTI as well, latch onto the dates of these terminations. But that ignores two key realities. These losses are ongoing, and the opportunity to present these claims would have occurred in 2021. Finally, Mexico argues that labor expenses would have been included in payment of the minimum or the maximum amount. They're correct. The normal cost of doing business costs of labor would be encapsulated by the payment of these amounts. But the forced terminations and ensuing litigations do not fall within routine expenses, and they could have been claimed but for Mexico's breaches of the NAFTA. Now, the final grouping here follows the same basic reasoning. Claimants have incurred significant attorney's fees beyond those incurred by their employment lawyer relating to the administrative rescission and the derailment bond, and they were denied the opportunity at the finiquito bargaining table to present these losses. But support for these awards can be found from the additional two breaches you found, namely the TFJA judgment and the continued litigation after Pemex settled with the Mexican nationals holding the 809 contract. First, we have Cristina Vizcaino. She initially worked on the administrative rescission lawsuit as well as a civil lawsuit. As you'll notice by the shading on this pie chart, we are not attempting to claim any losses from the civil lawsuit. Ms. Vizcaino should look familiar to you all. She was the target of Pemex's attempts to serve the unilateral finiquito. She also submitted a witness statement in support of our request for interim measures. For this, claimants incurred an additional $20,000 in fees that were paid to Ms. Vizcaino and should be included in the final award. Raul Lara primarily worked on the administrative rescission. His attorney's fees are on the screen in orange. Juan Carlos Mora is the man who continues to handle our employment lawsuits, but he too spent a significant amount of his time on the administrative rescission lawsuit. Similar to Ms. Vizcaino, the three of you should recall Mr. Pagliata. He was engaged because of his familiarity with the Mexican administrative court system. He briefly handled our appeal of the TFJA judgment, but ultimately withdrew to join Pemex's board. And finally, two different firms have handled our legal actions with respect to the unilateral finiquito and the call on the derailment bond. First, we engaged Fernando Fernandez, who worked for claimants from May 2022 to December 2023. He then passed the baton to our colleagues at Holland and Knight in Mexico City and Monterrey. They have been working on this matter since November 2023. Again, these losses continue to this day and have increased since submission of our last brief. We will update them accordingly. So to total it all up, this chart represents our attorney's fees that we would have presented at the finiquito bargaining table. Of course, we did not have that opportunity in breach of the NAFTA. Once again, Mexico questions whether these incurred losses truly belong to claimants. We encourage the tribunal to review the invoices, the cover pages, receipts we've submitted as evidence. All are addressed to Finley, Drake Finley, or Drake Mason. And again, Mr. Kernian is ready to testify as to how these lawyers have been paid for their work and how their time was divvied up for purposes of this damages hearing. Second, Mexico seemingly believes that we're seeking our fees for lawsuits that did not breach the NAFTA. That's incorrect. We're not seeking any fees relating to the civil lawsuit. And finally, Mexico repeats its argument from earlier about duplication of payment. Again, they are correct. However, these are not routine cost of doing business losses. They result directly from the decisions recognized NAFTA breaches. The last loss I'd like to address is a recent one. We received Mexico's counter memorial and damages on Friday night, September 26th, about 6 months ago, 5 months ago. In this brief, Mexico identified for the first time a judgment for almost $10 million in attorney's fees and costs in favor of Pemex relating to the civil lawsuit. That following Monday, Pemex appeared at our firm's office in Mexico City and demanded that we accept service of this judgment. Needless to say, this latest action is emblematic of the pattern of harassment and abuse our clients have endured for the last decade plus. It too would have been raised in the finiquito process that claimants were denied the opportunity to present their claims at. And similar to Pemex's active finiquito claims, it too should be included in the final award in order to ensure our clients' protection and finality of this decision. With that, I'd like to thank you all for the opportunity to present our additional losses, and I hope you will keep these figures in mind, particularly the greater than $50 million that Pemex still actively claims against our clients, as Mr. Melsheimer details their lost profits theory.
Cognizant of the clock, I will try to keep it brief. Imagine the shock I had when I saw Mexico's counter memorial that my clients were only entitled to $2.7 million. It was, well, shocking. What they tell you, and I've explained to you before, I think that the argument lacks all kinds of support and credibility for that matter. Mexico claims, without any support, I don't know if it's attorney argument, but there's zero factual support, that Pemex would have settled the 821 contract by paying the claimants lost profits for the remaining work from the contract minimum. When you make statements like that, you should at least back it up, either with a human being, something, maybe an example where they had done that before. Nothing. They continue. We calculate damages as the amount Pemex would have paid to settle contract 821, this is from FTI actually, to cover claimants' lost profits from the remaining 15 wells they didn't get to drill or complete. Show me an example Well, I ask FTI. I read FTI's report, and I encourage you to read it. For me, it seemed littered with instructions. Attorneys instructed this, attorneys instructed that, and I think maybe 6 or 7 instructions these attorneys gave FTI to conjure up a report. I'll let you assess whether the expert that Mexico has presented is impartial and independent based on all the instructions they got. But what's important to note, there's no support for anything that they're saying. It's just detached from reality. If Pemex would have wanted to settle for lost profits, they could have done it instead of issuing the bogus work order, right? I think that's the logic there. But it also defies reality when it comes to what you determine were NAFTA breaches. You determined that when Pemex sat down with the 809 contractors and continued litigating against us and did not sit down with us, that was a breach. We showed you, and I'll show you again, I think. They didn't settle for lost profits with the 809 contractor. They added lost profits to what they paid to the 809 contractor. And it's unfortunate that Mexico doesn't tell you that. So let's look again. The contract language is clear. 2 of the 3 of you are native Spanish speakers, so I'll defer to you on how you interpret ejercerá and podrá ejercer. Means will expend or may expend. Look at the 809 contract. We've just come to learn Pemex actually calculated the rate per day to be $73,352. That's Pemex calculating this. Coincidentally, it matches with the contractor's expectation as well. And that was all for time lost waiting for work orders. No lost profits there. Instead, they included indirect costs, indirect field costs, as well as financing costs. Yet here they're coming to you and telling you, we don't get any of that, we only get lost profits. One of the instructions that I thought was remarkable is effectively ignore what the contract says. Take as gospel what the Tuckma judgment says. Don't read the Tuckma judgment, but take as gospel what we tell you the Tuckma judgment says. I want you to look at the contract. It says clearly the theories that they're promoting here are just not true. They're not. None of this was based on lost profits. And everyone in the commercial department at Pemex, if they were here, it would be hard pressed to refuse what I tell you, that they agreed to at least the minimum. And they know it. They don't do this kind of behavior to get out of $2.7 million. Fundamentally, it's just a house of cards. You're going to have to buy a lot to get where you're going for this lost profits theory. Maybe you'll have to take instruction from Mexico's counsel to reach their conclusion too, like FTI did. That's the only way you're going to get there. Ignore language, add language, forget how they treated everybody else. So I'm giving you a summary slide here. Hopefully it's helpful. Of the losses, depending upon how you determine the true value of the 821 contract. You see the minimum amount, $216 million, that's plus interest, or includes interest, all the way up to $663 million. I don't think those numbers are unreasonable. Those numbers don't include the Dorama bond, the claims under the unilateral finiquito, and those that are the consequence of the unilateral finiquito. Now, soon, I hope, you'll sit down to draft an award. You've heard Mr. Porter and Mr. Browndorf, and I'll repeat again what I said earlier. Our clients deserve full reparation here. They've been through enough. When you hear, if you want to ask Mr. Finley when he comes up and testifies, talk to him about it. He invested money in Mexico in good faith through contracts with Pemex. Drilled wells for him. Wells are still producing oil for Mexico. How would you feel to have the rug pulled out from under you? Worse, how would you feel after having the rug pulled out from under you, having someone chase you around effectively with a gun, continuing to go after the Durama bond, seeking over $9 million of attorney's fees? So they need protection. When you draft your award, I want you to keep these in mind. They need to be protected. I know of visits that have been made down to Pemex's office for finding other issues that may have arisen. There are none. It won't stop unless you stop it. We need your help. And we need some finality. We started this 4 or 5 years ago now. I want, when you issue your award, we don't have to come back either to you. I don't know if you're able to come back. But I don't want to have to chase around the world. I don't want to have to fight any more fights with the government of Mexico. They don't deserve this. They need some closure. And with that, I thank you.
Thank you, Mr. Melsheimer. I don't know whether, Annalise, you can tell them how much time they spent.
They spent 2 hours and 36 minutes in their opening.
2 hours and 36. The left. So shall we break now for lunch for 60 minutes? Is what 12:42 at 1:45? Okay.